Okay, great. Next question says, how do you deal with an insurance company that has agreed in email to pay certain things, and yet a check has never showed up and they stop returning all communication? The outstanding amount would fall into small claims amount. Do I really have to go through that process?
Yeah, that's a great question. And as I said at the outset, there's really no legal obligation for the other person's insurance company to offer you a settlement. In this particular case, you might have some grounds based on contract principles that they agreed to pay you an amount. But in these types of cases, which really happens quite frequently, unfortunately, the only recourse would be to sue that person. Small claims is one option. Hiring a lawyer is another option. But yes, once you file suit, then you have the law behind you. Unfortunately, though, you're going to have to prove your case, and you may incur some expense doing that. But that usually is the only recourse that you're going to have if the insurance company either stops answering your communication or refuses to offer a settlement that they initially promised.
There's a follow-up to that. What if it is my insurance company, not the other parties?
That's a good question. And as I said at the outset, if it's your insurance company, you're going to have some added teeth in forcing them to respond. There are laws in place in Washington that govern how the claims practices should be handled. So if they're not responding promptly, one alternative would be to contact the Washington State Insurance Commissioner. Sometimes contacting the commissioner and lodging a complaint is enough to get your own carrier back on track and responding to your communications. Sometimes that's not enough. Sometimes the insurance commissioner won't do anything for a variety of reasons, in which case then you're back to square one, and then you may be forced to file suit against your own company.
Okay. There's another one here. It says, is there a statute of limitation for when insurance companies pay?
It depends on what insurance company. If we're talking about the other person's, the at-fault person's insurance company, we're talking about the statute of limitations for a typical personal injury claim, which is usually 3 years from the date of the injury or from the date that the negligence occurred or the date that the discovery of the negligence occurred. For first-party insurance companies, for instance, claims that you have against your own company under the terms of your own policy, normally the statute of limitations is going to be the same one that is used for contract cases. And in contract cases in Washington, the statute of limitations is 6 years. I have to caution people, though, that there are facts and circumstances that can affect when the statute arises or which statute of limitation applies. So usually it's a good idea to consult with an attorney to make sure what that statute of limitations might be for your case.
Okay. So we have a couple other questions here. I've heard that when someone hits you and the person who hit you's insurance company asks you to fill out a sheet explaining what happened in a car accident, you shouldn't do it without talking to a lawyer. Is that true?
To be safe, I usually tell people not to fill out documents or sign documents for the adverse insurance company. However, for smaller cases where the information that's being produced, for instance, might be a list of your medical providers or the names of witnesses. If you're going to be handling your own claim, then the insurance company is going to get access to that information anyway, so it might help you to provide that information early on in the claim. If you get beyond that, for instance, if they want documentation or for you to fill out a narrative report about how the accident occurred or offer more specifics about your injuries, then yes, now you're getting into a gray area where statements that you make or put down in writing can come back to haunt you in the claim. It may not haunt you. So it may be a good idea to have a lawyer look at it or consider it before doing that.
Okay. one other question here. My son was injured in a football game. He hurt his arm, but the coaches didn't do anything for him after the game. And he rode home on a bus for about an hour. And again, they didn't put anything on his arm, no ice or anything. So when he got home, we found out that it was broken. And now it's been several weeks later, and the doctors don't think that he will be able to fully extend his arm. Mm-hmm. Do I have a case against the school or the coaches, or what should we do?
Unfortunately, the short answer is maybe, and here's why. You likely do not have a claim against the school or the coaches just because an injury occurred during a high-risk sporting activity. Washington recognizes a doctrine known as assumption of risk. So getting broken arms in football is, I would argue, probably a risk of that activity. So probably a successful claim for the initial injury does not exist. However, if the coaches or the school failed to provide proper medical attention for that injury, and it sounds like they might have, when they should have known that medical attention should have been provided immediately or right after the incident, then there may be a claim for that alleged negligence. The real issue, though, comes down to proving if he doesn't have regular use of the arm, or if he can't extend it, the question really becomes, okay, is that due to the original injury itself suffered in the game, or is that limitation due to the delay in treatment that the district or the coaches may not have provided? That's not an easy answer or question to answer. It may very well require expert medical testimony. So if you've got a doctor that is saying, well, if the kid had received treatment right away like it should have been done, then he would have had no further limitations, would have made a 100% recovery. If you've got a doctor stating that, then you might have a cognizant claim, a viable claim against the district for the delay in treatment. But it's going to require some sort of expertise by a medical doctor to establish causation. That is, whatever the district did not do, delay in treatment, caused some of the harm that the boy is experiencing now, and that it's not due to the initial injury.
Okay. Well, thank you very much, Mr. Davis, and thank you, everybody, for joining today. Again, really appreciate everybody's time and hope that you had your questions answered. And